Does it make sense to charge someone with a crime if he had no reason to believe that his conduct was wrong? That question lies at the heart of efforts to reform North Carolina's rules regarding the Latin term mens rea. It's a topic that led to a recent forum at Campbell University Law School, and one of the experts who addressed the issue joins us now. Joe Luppino-Esposito is a policy analyst for Right on Crime and the Center for Effective Justice at the Texas Public Policy Foundation. Thanks for joining us.
Thanks for having me.
Before we get into mens rea, remind us, Right on Crime is a group that focuses on criminal justice issues nationally, correct?
Yes, that's correct. So we're based out of Texas, but we are a national campaign for conservative criminal justice reform. So we handle a wide range of issues, whether it's sentencing, prison reform, and mens rea and criminal intent is another big issue that we've been looking at in North Carolina and a number of other states and at the federal level.
Why is this mens rea issue something that's so important that it ought to attract some national attention?
Right. What's interesting about mens rea, I think Grover Norquist had once joked that, this isn't a new issue because we know that because it's Latin. This is a criminal intent law. It's a really basic tenet of criminal law, but unfortunately, thanks to regulation and sometimes just bad lawmaking, it has become an issue. What occurs essentially is that when there is a crime, there's not enough intent put in the crime. It may simply say, you may not do X. Well, if you do it by accident, then you're also guilty of a crime. But that's not what we learn when, the most basic thing that you learn in law school, which is that every crime must consist of a bad action and bad intent. And now we're going to be convicting people of accidents where we don't really mean to be.
And mens rea, for those who are new to the term and new to the issue, is talking about that intent. This is the intent piece of it,
right,
not just the action.
Right, yeah, it's the intent piece. And, we're all familiar with the idea of, say, first-degree murder, second-degree murder. These are different levels of intent. So this is something that even the layperson understands, but for some reason we sort of lost our way when it comes to making laws where that's just simply either not there or not done correctly.
Now, in North Carolina, is it correct to say that the problem with mens rea really isn't in these areas like murder or robbery, but it's in newer crimes, especially ones that have to deal with criminalizing regulations and regulation mistakes?
Right, absolutely. And, it's a maxim of law that ignorance of the law is no excuse. But that idea is around the opprobrium of moral crimes, right? These are the things that we're actually concerned about when we say that. But when it comes to regulations, it's very difficult sometimes to really know what is illegal and what is not. And you're absolutely right. When it comes to a regulation that may simply say, you may not knowingly submit this false form. Well, to what degree do you have to know even? Do you know that you mailed it? Do you know that it was false? Obviously, what we're trying to get at is that we don't want people sending in false forms, but there's a lot of things that can complicate this. And unfortunately, that's where we lose our way.
We are chatting with Joe Luppino-Esposito, policy analyst for the national group Right on Crime, also the Center for Effective Justice at the Texas Public Policy Foundation. So this is a problem you're looking at in North Carolina. Is this also a problem that we see in other states, that this mens rea or the intent piece of the crime is missing from too many crimes in other states?
Yes, absolutely. And actually, there are two states that took some action regarding this. So most recently in Michigan, they adopted what we would call a default mens rea term. So what they did was, for any laws that did not have a term, or if it was unclear, they assigned one of three different levels of either intent, recklessness, or willfulness. So in those cases, rather than just trying to guess if someone was doing something illegal, now we actually know if they actually had that intent. In Ohio, a similar measure was taken where any crime that did not possess a level of intent was assigned a level of recklessness as a level of intent. And further, any new crimes that go on the books in Ohio that do not have criminal intent in there and do not specifically say, look, we mean for this to be strict liability, meaning that there is no intent required, that law is just simply void.
Based on the experiences in other states, do you have a sense of how easy or how difficult it would be for North Carolina to make that type of change?
It can be difficult. And actually, the two biggest things that we found, both at states and at the federal level, our two biggest concerns are, first, the political one. Frankly, it's a lot of folks on the left, people who are environmentalists, sort of anti-capitalists, saying, look, someone needs to go to prison for whatever. Of course, when we talk about other aspects of criminal law and criminal justice reform in particular, we know that just simply locking people up does not really solve a problem. We need to talk about how to enforce laws, and there are other issues involved as well. So that's one issue that we struggle with, sort of a political one. But on top of that, we also just have the legal question. And this kind of comes from all different angles. It comes from prosecutors who say, look, it's difficult to see how we're going to handle this. What could we possibly do if you just pass a default term? We don't know all the laws that are in there and what this will affect. And to that I say, that's exactly our point. We can't just apply it across the board. Well, to protect defendants, well, then we shouldn't just be having laws that don't have this intent there. So those are two of the biggest reasons why we have difficulty in doing this. But there are other ways to do it besides the default term. There are things like recodification, where you look at the whole system overall, and you can say, look, we do mean to have certain intent terms for these types of crimes and certain penalties for other types of crimes. And that's really a more holistic way of looking at it and avoiding some of the issues that we've run into elsewhere.
I'm guessing some people are going to hear us and say this sounds like something of interest to some particular groups of lawyers who are haggling over this. If we did have some type of reform to our mens rea rules in North Carolina, what kinds of benefits would just the normal average person see?
Right. So, I mean, for anybody, either a small business owner or just an individual, there are a lot of crimes on the books in every state. And, I don't need to look at North Carolina code to know there are a lot of crimes that probably should not be crimes. And unfortunately, and it's not imputing any nefarious anything to anyone in particular, but if there is a crime on the books and someone wants to convict you of it and there is no intent, you will be convicted of it. To take a line from one of Stalin's ministers, you show me the man, I'll find you the crime. And unfortunately, that's a situation we are in, especially when it comes to regulations.
So if we see some reform of mens rea, that possibility becomes much less likely to happen?
Yes, absolutely. You won't be seeing those types of issues pop up because it's going to be clear that you're doing something wrong, or there's going to be no way for you to plead ignorance of that law.
Given your experience in other states, even if there is some difficulty in this process, is it likely that people who learn about this are willing to at least talk about it and try to make something happen?
Absolutely, I think so. A lot of folks, no matter what side of the aisle you're on and whether you're more pro-defense, pro-prosecutor, whatever you want to say, the idea is that we want to have justice here. And we don't want to just have people taking away their liberty just because of something that we don't like. The same goes when we talk about nonviolent crimes, regulatory crime. Let's really consider why we're taking someone's liberty away, why we're giving them a heavy fine. Are there other ways to deal with this? Let's look at that and really consider how it can be less damaging but still effective.
One of the things that the John Locke Foundation is recommending is to have just the complete, you mentioned this term earlier, recodification of the entire criminal code. Would something like that help?
Yes, absolutely. And it really gives the opportunity for everyone to come together, all the stakeholders, law enforcement, defense, prosecutors, everybody can come together and say, why are we really convicting people of certain crimes and to what level we want to do it? Because a lot of times crimes are created and penalties are given, but they don't really match up with other things that are on the books. One of my favorite stories is from the federal level, when John Kerry was a senator, and right around the time of the 100th anniversary of the sinking of the Titanic. He proposed a bill that would make it up to a 5-year penalty for disturbing the Titanic site. Now, not only is that just silly, we'll put that aside for a moment, but there are already laws on the books of disturbing artifacts that had a penalty of up to 1 year in prison. So he's now making a special crime for something that probably shouldn't be a crime in the first place, or at least not in our jurisdiction of dealing with, and making it 5 times worse than a law that's currently on the books that would serve the same purpose. So recodification allows you to pull out laws like that and say, this is how we've gotten a little uneven, let's try to fix this.